I'm Adam Winkler. I'm a professor of law at UCLA School of Law here in Los Angeles and the author of Gunfight, The Battle of the Right to Bear Arms in America. Now that the Supreme Court has reinvigorated the Second Amendment and clarified its meaning, the question is, what does that mean for gun control? Does that mean that many forms of gun control are unconstitutional? What I tried to do in this book is to look back and to say, how have we tried to balance gun rights with gun control through the course of American history? For while the Second Amendment has long been ambiguous to many lawyers, it's very clear that the right to bear arms is still one of the most established constitutional rights that Americans have. We don't have to look at the Second Amendment. We can look at the state constitution. Every one of the 50 states has its own constitution. 43 of those states protect an individual right to bear arms, clearly unrelated to militia service, with cases going back to the early 1800s clarifying that this is an individual right to bear arms for personal self-defense. But what I found in doing my research is that right has always coexisted with gun control. In other words, the fact that we've had a right to bear arms does not mean that government cannot enact gun safety laws that could be effective to prevent crime or criminal misuse of guns. So one of the larger overarching points of the book is to show that gun rights and gun control have long existed side by side, and then to show all the fascinating and surprising ways in which efforts to balance those two, gun rights and gun control, have shaped the nation. Well, the NRA today claims to be an inheritor to the founding vision in protecting gun ownership. But the founding fathers had gun control laws that were so burdensome that were Madison running for office today, the NRA would never endorse them. The founding fathers not only barred large segments of the population from owning guns, namely slaves and also free blacks who otherwise had the vast majority of property rights, were denied this particular right, but also political dissenters. In the years before the Revolution, if you didn't swear allegiance to the crown, you could be disarmed. And then once the revolution took hold and the political winds changed, if you didn't swear an oath of loyalty to the revolution, you would be disarmed. Now, we're not talking about people who were fighting for the other side who got disarmed. We're talking about people who were exercising their freedom of conscience and their political beliefs and who just didn't support the revolution, thought it was a bad idea. Historians believe about 40% of Americans at the time thought that the revolution was a bad idea and that we should remain part of the crown. But those people were subject to disarmament. But then there were also a whole series of laws related to the militia. As I mentioned earlier, the ordinary citizens were the militia. You've heard about the Minutemen who had to go grab their gun in a minute and show up to fight. Well, that was the militia. But the founding fathers had very strict laws that they imposed on members of the militia. Number one, they had to go out and purchase a military-style firearm that met certain specifications under law. So even if you had a gun or didn't want to own a gun, you had to go get the specific type of gun. It was their own version of the individual mandate that's proven so controversial in President Obama's healthcare overhaul. And then when you had this gun, you had to show up at mandatory musters where your gun would be inspected and registered on government rolls. The founding fathers believed in civilian ownership of guns, and the government should never be able to take away all those guns because that would lead to tyranny. But they did not believe that gun ownership was a libertarian license to do whatever you wanted with a gun. They imposed very burdensome restrictions on gun owners. No, there were very few definitive statements. What you do have in the history is a lot of discussion of we the people being the militia, and we the people as a militia needing the right to keep and bear arms to protect ourselves. One of the most important dates in American history actually happened long before the Revolution, and it was back in 1689 when the English Bill of Rights was first signed. The English Bill of Rights was adopted when William and Mary took over the crown from King James II. James II had tried to disarm the people and had violated a whole set of their rights, including their right to be petition the government for redress, a right to be due process of law before you were imprisoned. And one of the things, when they ousted James II, one of the things they did, the elites in England, was force William and Mary, as a condition for taking the throne, that they sign this English Bill of Rights that protected the rights of free English people. the framers used that same Bill of Rights as a model for them 100 years later when they were devising their own Bill of Rights, and indeed protected many of the same rights, including the right to be uh, uh, free of unreasonable searches and seizures, the right to due process of law, and the right to keep and bear arms. So we know more from the historical context than anything else. There were a lot of statements about, I don't mean to suggest there were no statements about what the meaning of the Second Amendment was, but hard to translate into today's meaning because all we know really is that it was really focused on protecting the rights of we the people as part of an unorganized militia to have guns and to be free from disarmament by the government. But it doesn't tell us very much about background checks or bans on machine guns. Thank you very much for having me.